Sally Babbitt, attorney, mediator, and author, is joining us again in studio. Sally, there's a 3-part series on wills, trust, durable power of attorneys. Tell me more about this.
So I decided that the next 3 segments I would break apart what we consider the most common documents that people should have in their estate plan. So I thought today I would focus on the will. Most people are most familiar with a will, although I don't think they understand them the way that they should.
Okay, tell us what the will does.
The will does a few different things. It takes effect upon the person who created it, the testator's death, not before. And it can do a few different things. If you have minor children, then you can nominate a guardian and a conservator for them. You can designate a funeral representative, which is becoming more and more important because we're seeing more and more conflict as to who can authorize cremation, who gets to make decisions about burial, especially with blended families. So we're seeing more conflict there.
Yeah.
We can also use the will to direct the disposition of assets on your death that don't have joint ownership and don't have any kind of transfer on death or beneficiary designation. And should the need arise, it's the personal representative who's nominated in the will who can authorize like HIPAA releases, medical records. This would come into play if you suspected a medical malpractice suit or something like that.
Then what does the will not do?
So the will is somewhat limited. It cannot direct the disposition of assets that are owned jointly or that have a designated beneficiary, transfer on death, TODs, those kinds of things. It cannot direct those assets. It does not avoid probate, and that's a common misconception. Okay, it actually directs probate. Yeah. And I think the biggest reason I see people not just use a will but add a trust, which we'll talk about in the next segment, is that it does not allow you to plan for a lot of what ifs down the road. I call it a one and done. But if you have minor children or grandchildren or beneficiaries, if you've got people that have special needs, those things really need to be addressed in a trust, and the will just doesn't do that for you.
A lot of people think they got to wait until they have a lot of money or assets piled up before they create a will.
Right.
That's not the case, right?
Absolutely not, especially young families that have young children.
Yeah.
Obviously they're probably not going to accumulate a lot of wealth, but critical for that.
Sally Babbitt, Babbitt Legal Group. Go online to find more. Thank you, Sally.